Okay, so the info slide for round 7 is there are legal rules that limit how law enforcement may obtain evidence, such as requirements to obtain a search warrant before conducting searches of a property, prohibiting certain types of surveillance, or requiring police officers to be able to justify conducting a search of someone's person. Evidence gathered in breach of these rules is considered improperly obtained and is generally inadmissible in court. However, in many countries, courts may still allow such evidence in circumstances where a serious crime is alleged, and excluding the evidence would significantly harm the prosecution case. The motion for round 7 is this House believes that courts should never allow improperly obtained evidence to be used in criminal trials. Now, regular speeches will be 8 minutes long. I will clap once at 1 minute, once at 7 minutes, and then twice at 8 minutes. And for leaders' reply, I will do it once at 3 minutes and twice at 4 minutes. You're welcome to second speech.
Minorities are already disproportionately harmed by the justice system, and this is only accentuated by allowing more room for interpretation and discretion surrounding illegally obtained evidence. A few things in this speech, firstly on setup, secondly on the principle of consistency within the justice system, and then thirdly on why the NEG side is particularly exploitative. Okay, firstly on setup, how do police obtain evidence? One, they find cause. This looks like an ongoing investigation case towards searching a house or seeing a probable cause, e.g. seeing signs of struggle. For example, if you hear yelling from coming inside the house and you knock on the door and no one answers, there are legal systems that mean you're allowed to now go in and search. But also two, you follow a process. This looks like A, building reasonable suspicion and following the correct processes and emerging systems, and the ability to go inside. But the majority of the time, you get this warrant signed off by the judge. But note that in emergency situations, you can expedite a warrant and it can be done and signed off very quickly, and if there is clear signs of imminent danger. But B, you execute it correctly. This means if you get a search warrant, you have a supervisor on scene, you have a support, and you have a strong chain of custody. But C, the chain of custody is secured from the moment the evidence is secured until processed. On negating side, in instances where serious crime has been alleged and prosecution believe excluding evidence would harm the prosecution, they could file to have their evidence at the judge's discretion. Okay, before I move on to my first point, I'll take a POI.
Police officers are likely going to collect this evidence anyways while they do the crime, so why would it be potentially exploited?
Police officers are likely to collect the evidence anyway. That's what I'll go over in my point. Okay, firstly on the principle of consistency in criminal justice. Criminal justice is a very high stakes institution. Any small mistakes means a person getting imprisoned for life, or in certain countries death. We just emphasize that having consistency in legal matters is very important for these reasons because of this value behind it. Note that this is specifically important because court prejudice against certain groups making mistakes. The court consistency is there to reduces the likelihood of mistakes being made, but also it reduces the actual high stakes of having to make these discretionary decisions surrounding this case. For example, you have things one, legal precedent where the highest court have the right to say how legislation is interpreted to ensure consistency so that everyone follows it in a consistent way. But two, this is why we have a very meticulous process of obtaining evidence to ensure exact processes and chain of custody leading up into the prosecution, so you can have the most processes case by case. So it's most consistency case by case, and this removes the chance of having these inconsistencies that matter so much within actually being able to enact this law. In this debate, NEG wants to remove a very important accountability mechanism for ensuring consistency. A, less thoughts go into searches because there is no need for a warrant if you truly believe that you want to get this evidence, but B, evidence is less reliable because it comes from sources that didn't properly validate, or just not effectively follow the chain of custody. But C, you allow it to be permissible at a very abstract level. This is at the judge's discretion, and it depends if the prosecutor is motivated enough to apply for this. And even if you believe that there's slightest chance of any of these mix occurring, you should buy the significant harm to the integrity of the justice system as a whole. One mistake is one life wasting away in jail with no opportunity to escape, especially in the instances of this case is serious crime, so it's quite likely these prison sentences will be long, will be serious, the conditions will be worse. So now why is this exploitative? So why is the justice system already prone to inequity? One, you have inherent human bias. I think individuals like judges, etc., have to make decisions that are contingent on law, but also the way they interpret law and their own experiences. I think you have unconscious bias to favour someone you relate to because you your opinions form through lived experiences, so you understand individuals more if you have shared experiences that are very relative. But also two, you just have a lack of representation. I think historically only white males are in these positions of powers such as judges, or in most countries men hold majority of police officer roles within these law enforcement agencies. So there's just not enough minorities in these systems, so they don't have this representation. But three, you have structural bias. I think you have a history of white male dominance in this field, and this is reflective in how the justice system itself actually operates. The systems and ways laws are interpreted are surrounded from this. I think this also looks like more policing in low-income areas because this is where the old rich people used to think all this crime fostered, and this is where they were gonna put them all in prison so the areas were nicer. So why is this improperly obtained evidence abused? One, there is too much room for opinion. This means if a cop thinks someone looks suspicious and searches with no cause of evidence, this can be used to find someone guilty. This means this cop is now incentivized to search people who look like a criminal to them. Note that this is particularly likely to happen in that if you believe that individuals who are working in this justice system have a strong sense of justice, they've been targeted by messaging that have recruited the justice system through enacting justice. But I think secondly, this means it incentivizes over policing people. This looks like putting cheap, unreliable surveillance in minority areas and expecting that could be used for evidence because it could be if it was required. But thirdly, this looks like can be actively exploitative, tampering with evidence and lying about where you found a gun because you strongly believe this individual could be this serious offender and you want to persecute them. But I think fourthly, there's a lot of room for opinion. Which prosecution gives the most convincing case that the evidence should be used, or which judge allows it to use it. This means, one, at the very least, people perceive this bias and abuse as possible. This means that people from communities prone to bias from the justice system feel vulnerable. Every time a cop looks at you funny, you don't know whether they're going to come over and pat you down, or just walk past. There's this lack of consistency that is really, really scary. And when these marginalized communities are particularly prone to it, this is when the distrust in the legal system only fosters because they have they feel they're actively being targeted in a way that they are this inequality is further being prospered. But secondly, I think the system itself is just prone to abuse. This looks like cops being able to go out and enact their own biases, searching individuals who otherwise wouldn't be there, or tampering with evidence. Note that this exists on the scale where these cops actively do it or subconsciously do it, and then it can't be used. This is so important because we want to ensure our legal system is held to the highest standard because of these harms that we've illustrated. This is why the moot shall stand.
I thank that speaker for their speech, and I now invite the first speaker from the negating side to take the floor.
I'll begin my speech in 3, 2, 1. Criminals of serious crimes of rape and murder should never be allowed to run free no matter what. They should never be allowed to potentially harm another innocent person. I am so proud to negate. I'm going to be doing 3 things in my speech today. First, in points of setup. Second of all, explaining why justice is better served on side opposition. And thirdly, on why we improve public safety. Firstly, on setup, then 3 questions to answer. Firstly, what do we think that this serious crime looks like? We think that this means that these serious crimes look like crimes like rape, like murder, crimes which have huge impacts on people's lives and which can literally make the difference between whether someone is convicted or not. But secondly, how do we think that this information is collected? 2 things. A, we think that it tends to be collected in a way that is fairly accurate. That is because, first of all, it is just collected from good sources. For example, we are prepared to stand for improper surveillance, but regardless of what you think about the ethics of that, the information collected is likely going to be highly accurate. But also, 2, it tends to be done out of surprise, right? That means that the criminals do not know that such is coming. They don't have the time to cover it up, so therefore it's more likely to be accurate. But second of all, we think that we just have the same metrics to determine accuracy as we do on side proposition. That is, even if you do not follow the correct procedures when you are collecting the evidence, the court will likely still follow the correct procedures when deciding whether to verify this evidence or not before using it in court. Because I want to note that on both sides of the house, we are never going to be using information that might not be accurate. The question is how it is collected, not the problem of accuracy. That means that the court is still likely to dismiss a evidence if it could easily have been faked. It means that the accuracy probably still matters. But B, we think that there still exist metrics against abusing improperly accused information. That is, first of all, while the information may still be used in court, police officers are likely going to be punished identically on both sides of the house if they perform misconduct in the collection of the crime. This just means on a basic level, I think you should believe that most police officers do not feel this huge additional incentive to search people even more because they are aware that things might happen, like maybe they lose that promotion that they've been trying to get, or maybe their career is derailed, or maybe they just face some form of punishment. But second of all, even if you believe that these police aren't punished for some kind of reasons, you should still believe that this is kind of symmetrical on both sides of the house. Since the information has already been collected, the only choice is whether we use it or not. But thirdly, I want to frame how the justice system works. And that is that note that this deals with the accusations of bias that props gives us up. Because I just want to note that bias is symmetrical. The justice system is always going to be interpreted by the same people. The judges who decide whether to use this evidence or not are the same people who are deciding whether to judge this person guilty or innocent. Insofar as you are trusting this judge to make this incredibly important decision, you should believe that this trust should probably extend to them having the decision to include the evidence or not. On to my first point then, on why justice is better served, but before I do that, I'll take a point. 3, 2, 1. Alright then, on why justice is better served. The first thing that I want to prove is why courts just run faster. And I want to give you the framing that in the status quo during serious cases, courts run very slowly. This is because courts are often very bureaucratic, which means that when you are deciding whether to use this evidence, whether it was illegally obtained or not, that is quite a long process that that involves asking police, or checking the police cams, or taking reports from the accused, and it's just this very long trial in order to actually verify whether this information can be used. So what this means is that serious crime cases usually take a very long time to be pushed through. In our comparative, however, that is a step that can be skipped, because if the crime is serious enough, all evidence is immediately considered the second that it is verified to be accurate. This is important for 3 reasons. Firstly, to the accused. Note that the accused, especially if they are extremely vulnerable, usually have to sit a long time on bail the further the case drags on for. And this is especially harmful for lower income people because it means that they cannot pay their bail and they have to sit in prison. And so even if they're innocent, it means that when the case is pushed forward through, they are still harmed. But second of all, to the victim, when the court case drags on, they are the one who are repeatedly called back to testify. This disrupts their life because they can never move on from the harm that was inflicted to them. This disrupts their mental health. But more so than that, it causes a financial harm to the victim because they always have to call back their lawyer. They always have to go to more court cases, this is a harm you should weigh highly. But thirdly, to the court, note that when important criminal cases are there, often this redirects attention to these cases, which means that less serious cases are often neglected. But even if you don't believe that, you should still believe that during large court cases, usually a very large court backlog is formed when you have to spend all your resources on focusing on this very large case, which means that just later cases are delayed or slowed down. Note that these cases being run less efficiently extends the harm to those other criminals, because it means that these petty criminals also have to sit longer on bail. It means that those victims also have to spend longer paying their lawyers. That is just a very big harm that extends to them. But second of all, on the principle of the court's purpose to actually enforce the law, I have two things here. First of all, principles are made up. We think that the reason we care about the principle of the court is because they protect people, is that they protect people's rights. But insofar as that you cannot access any possibility to access these rights when the court isn't properly working, when the court is working so slowly and you can never actually get the right of justice that you deserve, that is a harm that still exists on side negating proposition. But second of all, we think that the principle of victim safety just should overweigh the principle of privacy for the court, because the criminal has already violated the rights of others. They have taken away someone's rights to a mother, someone's rights to safety, someone's rights to lead a rest of a full, meaningful life. We think that at the point of where these people have already taken someone else's rights, they do not deserve the same rights as these victims. I'll take that POI.
What happens in situations where the accused is innocent?
As we've already explained, the same metrics to verify whether the information is accurate still exist, but more so than that, we just can't use this evidence sooner and do this trial sooner. So if this victim is innocent, that can be decided sooner. They can be released sooner. They don't have to sit in prison for years and years while they wait for the court case to pen. But second of all, on public safety, at the top of this point, I want to flag the instances where evidence is used, where excluding this evidence significantly harms the prosecution case. For example, if a woman is killed and her DNA is found on a knife in the accused's pockets, not using this evidence means that the perpetrator might never be sentenced at all, or at least might take a significantly longer time to sentence. First of all, it is extremely harmful if this penetrator is released, because this means that they are able to further harm the public. If a rapist is released, they are able to rape another person. If a murderer is released, they are able to murder another person. They just have this reason to keep on offending, because they have already shown this large capacity for violence. But note that this danger to the public poses the most important impact to this debate for two reasons. First of all, you should always weigh the avoidable harm to innocent highest in the debate, because it is the most proximately impactful. Rape can ruin your trust, can require years of therapy. Murder robs your life and harms your friends and family, who always have to live with the guilt and sorrow of your death. This criminal's right to privacy should not overweigh an innocent person's rights to feeling safe, to speech, to autonomy, to all the rights that can be taken away when the criminal is allowed to act. But second of all, on minority communities, if you believe that they matter, you should believe that they are benefited when these serious criminals are jailed. Because if this criminal is from a minority community, they usually commit crimes within this minority community. When they are jailed, the minority community is safer for it. I'm so proud to negate.
I thank that speaker for their speech, and I now invite the second speaker from the affirming team to take the floor.
When you enable police officers to pat down a random person just for the hope that they could have a weapon on them and it could be admissible in court, you change the system to actively target minorities. That is a very severe harm that the negating team cops in this debate. Look, firstly on how the model works, then on the comparative, and then on victims. Look, Basically, their entire case is developed around this idea of their system being quicker. Look, we tell you firstly here that that is absolutely abhorrent because people are then more prone to mistakes. Why? For A, they're just inherently less likely to think things through when you have less time to think. But B, you act in the heat of the moment. Note that being a police officer is a pretty intense job. We think that if you are acting so quickly, you are acting in the heat of the moment. But C, you just then have less checks and balances. You have less accountability mechanisms applying to you in that short time period. What this means is that you're more likely to A, harm the cop in this instance. It looks like a police officer rushing in to a house without a warrant where a criminal is waiting there with a weapon to hurt them. That is not a good benefit. But B, that's more likely to make mistakes that lead to bad justice. This looks like losing the chain of custody of a weapon. It looks like allowing for it to be tampered with because you rushed in, you scared the criminal, they threw the gun out the window, and now you can't find it because you didn't go through proper channels to come up with a strategy that would have effectively obtained that evidence. But secondly, we can claim the exact same benefits without any of these harms, right? We tell you at Layla that we can expedite warrants within like 20 minutes. You go to a judge's house and you get them to sign it. If you've watched The Rookie, you know this is true. But B, probable cause exists. If you hear someone screaming, a cop's not going to wait for a warrant. They have legal grounds to rush in and save that person. So given that their entire case sort of rests around this one benefit of getting things quicker, we can claim the exact same benefits, but with unique accountability mechanisms, unique ability to keep cops safe, and to ensure consistency through the justice system. We don't think, and like, look, even at our very worst, where we sacrifice, half an hour of time, I don't think that's enough to be a sufficient burden on the courts that you should buy any of the material on the courts burning out. Like, this is a ridiculous harm. I think that even at our very worst here, the government is willing to put more money into the justice system to ensure that that criminal justice is executed properly. I can't believe we're impacting on having too many cases in the courts, seriously. So then they tell us that it's never inaccurate. Firstly, speed equals mistakes. I think it's pretty intuitive that if you act quickly, you have less time to think, you're more likely to make mistakes, at the very least. But secondly, this only applies to cases where accuracy is impossible to verify, right? Why is this true? Because otherwise, it would be admissible on our side of the house anyways. So that means that the only evidence that exists on the negating side of the house that is actually affected by this policy change is evidence where it is impossible to verify the accuracy of it. So what this means is that they can never assert to you that the evidence is never inaccurate because they never know if it's been tampered with. They never ensure the chain of custody stays effective. I'll take a POI.
Note that we don't actually have to support using more improperly obtained evidence, but when this improperly evidence already exists, we believe that if we have already verified it, we can use it in criminal trials. How would you deal with that?
If it was verifiable, it would have been obtained in a way that is admissible. It would exist on our side, that's symmetrical. But we tell you the threat, even if you don't use an unverifiable evidence, the threat of that being able to be executed is enough to harm minorities and harm people who are scared of the police and who have already been disenfranchised. Just the fact that you could have an inconsistent justice system is a huge principle that Layla gives you a lot of material on, and they say, oh, we don't care about principles, these freaking Aucklanders, guys. So why the comparative makes more mistakes? Firstly, there's less need to think things through, right? It's hard to punish something as ambiguous and abstract as evidence that wasn't obtained properly. Note that police do act in the heat of the moment. They have the capacity to act irrationally, even if they are good officers, right? Things just happen, mistakes happen, they're humans, and especially they're in a high stress environment. Look, it's very ambiguous then to qualify what is valid. But secondly, it incentivizes using discretion more regularly. Even if this is just small incentives like doing the paperwork on the warrant after your shift, or spending less money on verifiable CCTV cameras. So this means that the justice system is more incentivized to use this system when it is extremely unnecessary. We tell you that this is extremely bad from Layla because it means you get a disproportionate effect on minority, low socioeconomic communities where there is a perception of more crime going to happen by a justice system that is systemically against these people. Yeah, I'll take POI, sure.
Are minority communities not more harmed when violent murderers are allowed to run free because the evidence against them has.
Okay, I'm going to do victims as my substantive soon. So then on the comparative, we tell you, like they tell us in a POI that we collect evidence either way. The difference then on our side, if it wasn't clear enough at Layla, is that we have accountability mechanisms. This means you have to think through and build up a case before getting a warrant. You have to get sufficient proof. You then need legal grounds to prove that you can get that, and you have a process to execute it, right? This looks like having a shift supervisor on scene to help execute the warrant and make sure it is gone well, or B, like having clear guidelines of what qualifies for a legal search. This means when there is a clear method, there is certainty that the evidence is good, so it's easier to prosecute the criminals who do it, who we are sure about. That negating cares so much about, but also it's easy to hold cops accountable when there is a clear process. The comparative is like he could have evidence. It's too abstract. You can't fire a cop just for like thinking like, oh, they maybe did have evidence. So that just means you get all of these bad police officers walking around on their side. You get far more police brutality and far less certainty in the justice system. So then on victims, look, being a victim of a serious crime is very traumatic, right? You go through like violent physical trauma and like emotional trauma, right? You never feel safe. You feel like confused. You have conflicting feelings. This often looks like self-blame, but also you're just deeply betrayed by like a fellow human who is someone like you should trust. So why did NIG not get less? Why did NIG get less justice for victims? Firstly, because especially in sensitive cases, they are largely unrepresented. This looks like sexual assault victims who don't get evidence admitted because there is a structural bias against women in the justice system because there is such a disproportionate amount of male presence in historical grounds, but also actively participating as judges. A male judge is less likely to get it. They're less likely to use their discretion to allow evidence to be admitted. But secondly, it's unreliable, right? The evidence is less likely to even be effective in the case. They get their hopes up, but it gets disproven, and you just set them up for failure, essentially. But thirdly, even if the system works, victims still importantly feel like they never get justice, right? It's never certain because it's inconsistent, and they're already like skeptical and confused and conflicted, right? But B, there's maybe an element of self-blame. Like, did this person really deserve it? You're not sure because there's no consistency in the justice system. It's not just important for victims, like we tell you at Layla, but it's for criminals. It's important for victims as well, and the security of the entire nation. What does this mean? Firstly, even without bad execution, there's still doubt. You never feel fully validated. You never feel like you can fully recover from your crime because you never feel 100% certain. But secondly, you get set up for failure. You spend all this money on legal action. You get your hopes up. You're actively ignored and betrayed by a system that is supposed to be the only validation you get after going through a traumatic experience that's really harmful.
And I now invite the second negating to.
Hey guys.
Affirmative misunderstands our case because we didn't have to support doing more improperly obtained evidence. What we do on our side of the house is we have this evidence already, but we are able to use it in trials. We are able to help victims. We are able to make the justice system better. We are able to improve our world. A few things in my speech. First, on how data is collected, second, on the principles, and finally then, on minorities. First, in how data is collected, the affirmative claim here is that because we allow it to be used, there's going to be more data that is obtained improperly. Two things. First, I'm going to explain why the premise of the argument falls short. Second thing I'm going to do is contend with our worst case. First of all then, why does this argument from affirmative simply not work? Most data is collected by the police. Note that they have search warrants and justifying searches for individuals. Ollie tells you they can do this very quickly, but then he gives you a lot of material about why quickness is bad, why rushing into things is bad. I think they have a huge contradiction and tension in their case that they need to deal with. But look, search warrants aren't that easy to get, but the incentives of police will remain honourable on either side of the house. This also explains why we're not going to violate principles and why they're equally unlikely to happen on both sides of the house. First of all, police care about honouring the law. This is literally their job. They care about society. They take huge risks, their own lives every single day. This ought to show to you that they care about the people that they work for. They care about the communities that they are in. But second of all, they literally risk losing their jobs if they act illegally. There are accountability mechanisms like body cameras that mean they can't just randomly search a minority if they feel like it, because people are going to still have accountability mechanisms in place to make sure that police act in ways that are honourable and in ways that are good. This explains to you that police aren't going to just randomly start collecting lots of data. And what it means is that the data that we have already is just usually collected anyways, and it is accidental, it happens on the process. The change is between whether or not it is going to be used. Here I want to whip balance material on all the stuff we explained to you about how we're able to improve the justice system, because you actually prevent further backlogs, you're able to improve this. But look, the affirmative push here was that there's going to be less thoughts in searches, and so you're going to search minorities more. First of all, the calculus doesn't change because I explained to you that police still act honourably. But in our worst case, even if you are giving these marginally less thought, we are still able to win. Because on affirmative's metric that you need to keep the justice system consistent, if police just search with less thought and you believe they are all evil human beings who are all racist, then this is still a change that occurs on a baseline level. It happens on a broad scale. It is still going to be consistent. The justice system isn't harmed. But now I'm going to explain more thoroughly why the principle just doesn't work. Before I do that, I'll take a point.
Using the same logic as your victim point, when a murder is committed, should we arrest all the suspects to ensure everyone's safety?
Obviously, you shouldn't arrest every single suspect to ensure people's safety. What you do is you arrest the person who committed the crime, but the only side you are able to do that on is on our side of the house, because you actually have the data to go through with this decision. On your side of the house, you were stuck in this cycle where you are unable to continue with the case because you never have enough data to figure out who was the murderer. I'm going to explain why the principle of the consistency in justice system simply doesn't work. For you to believe that they are able to win this principle, you have to do three things. They have to prove that it existed, they didn't do this. They have to prove that it was uniquely discharged, they also didn't do this. And third of all, they have to prove that they are able to discharge this principle well, they didn't do this. Firstly then, the consistency in justice system principle simply doesn't exist for two reasons. First of all decisions are different. Every single case involves different victims, involves different criminals. There are no two cases that are the same, and consistency is always going to exist within the justice system. Secondly then, you decide consistency on what is considered to be good and moral. And look, courts have literally no objective system of morality, because every single court in the world claims to be moral, because every single court in the world operates on a set of beliefs that are derived from first principles that literally no one can prove or justify. This explains to you that courts have no objective system of morality. They have inconsistencies, and because these exist, we take down the premise of their principle. Second of all, even if you believe this principle exists, they are unable to prove that they uniquely discharge this principle, because courts try to make the same decisions anyways. Even if it is inherently inconsistent, they try to do this. I already explained how any changes happen are the same across any court, because this is broad changes on the baseline level. This proves to you why they aren't able to uniquely achieve this. But third of all, they don't fulfill this principle in the best way possible, because you still have differences in every single other part of the justice system. There are still going to be inconsistencies. And this is especially bad now because judges don't have enough material to consider the decisions to be able to actually follow through with the decision. I flagged this earlier in my speech, right? First of all, it is super slow because they try to collect proper information. If you believe this, you have to buy all of Bella's material that she explained in her speech that only got a hand-wavy response from Ollie. Second of all, If you don't believe this, you just believe that the judges are now going to make decisions with limited information. This is when they actually make bad decisions that harm minorities. I'm going to explain this a bit later, but what you have to believe at the end of this is the principal simply is not able to win them any ground in the debate. I'm going to really quickly contrast this with a future victims principle, which you should weigh highly. Because the premise of, the idea behind this principle is that because there are victims that have already suffered in this world, the best thing we are able to do with the justice system is to prevent and prioritize these future potential victims and to ensure that no harm occurs to them. The best way and the unique way you were able to do this was when you were able to use this evidence against these serious criminals. Because on affirmative, if you never allow courts to use this, you are never able to actually arrest this criminal. They are able to continue perpetuating harms. You don't fulfill the future victims principle. I think you ought to weigh this highly. Next thing about minorities. The idea here was that judges are going to be biased. The first mechanism they gave was that because judges give decisions to people they relate to. 4 reasons why this mechanism doesn't hold. First of all, judges have legal expertise. The selection of judges is rigorous and needs good proof that you aren't biased. Second of all, you just have to write reasons to justify what you have said, right? You have to make it clear why you have made a certain decision. Third of all, you have to publish reports with your decisions. These can be publicly reviewed and appealed. You ought to make sure that you aren't biased. This can harm your reputation. Fourth of all, that you have professional accountability. If it is really bad and you are a biased judge, you're going to be removed. You obviously want to keep your job. You're not going to act in a terrible way. The next idea they give you is that there is structural dominance of white men. Look, I think we are already shifting away from this, but the structural reason for why you don't get this is because judges come from places of elite education. And note the framing here is that in these areas, there's going to be a left-leaning environment because the uni environment is dominated by young liberal communities who push these liberal ideas. What this means then is that you have to believe that judges are going to act in ways that aren't pernicious to minorities. But we're going to flip this because judges, if you believe that they are going to be bad, they have increased capacity to act badly on affirmative because they have literally no data to contest their decision. This means 2 things. First of all, they are likely to defer to previous cases, and the particularly unique harm to this is because there are structural disadvantages to minorities. In these previous cases, there are likely to be evidence that is stacked against them because it is proven that structurally, historically, the data is that minorities commit more crimes. If there is no proper evidence to analyze the situation, these minorities are going to be the ones that are convicted. This is very, very harmful. The second thing is that because there is a lack of proper information, they're just going to defer to individual biases. If you believe affirmative that judges are going to be bad, then you ought to believe that they're just going to be far worse because they have no proper data that they are able to use to make sure that they make the best decision properly. At the end of my speech, what you should believe is that, first of all, the principle just doesn't exist. We contrast this with our future victim principle. Very important, also extends on the material that Ballard gave you. Secondly, then, we prove to you why minorities are actually not going to be harmed, and if they are harmed, it happens on affirmative. And the final thing that we explained to you was why we don't support more improper data being obtained, why this doesn't happen, and how we win this debate. Very proud to negate.
I thank that speaker for his speech, and I now invite up the third speaker for the affirmative team.
If a rapist is not convicted on our side because the police officer didn't legally or justifiably obtain the evidence so it can't be used in court, that is his burden, not ours. We should never stand for a world where police are above their own rules that we set for themselves. We don't stand for a world. We stand for a world where there is zero incentive for the police to break rules. Police are not above their own rules. Principles may be made up, impacts are not. I'm going to go through 3 points of clash. Firstly on quality of evidence, secondly on exploitation, and thirdly on the principles. So firstly on evidence. and like just the court process. They said it takes like way longer, and they gave all these silly impacts on like lawyers. And so firstly, like I'm pretty sure Ollie responded pretty sufficiently to why it doesn't actually take longer on our side, but to extend on this, why is it actually worse on their side? 2 reasons. Firstly, like they said so often, the only evidence going to be used is like evidence that is accurate. Why is this going to mean it's going to take way longer? Because when it wasn't properly obtained, when they didn't go to a judge to get a search warrant, no one knows if they like were wearing gloves when they obtained the evidence. No one was there for checks and balances. No one knows if they like stored it properly. There is just like when there's a slight chance for like tampering with their evidence, I think we can agree that judges are predominantly good actors. They're going to want to make sure that this evidence is accurate when they're using it when convicting a serious crime, as someone could be facing something like life in prison. This is going to take so much longer than any of the like weird mechanisms they gave for our side. And then so there's no checks and balances. It takes time that's not properly obtained. Like even if you have the best incentives when you're collecting the evidence, they still need to check and make sure it's accurate. Like this is in their best case where they are going to make sure there's no exploitation. And secondly, they just have to like figure out if it's necessary and should be used. This once again just like takes more time. What does this mean? We can flip all of like their good impacts about the effects on victims and why it's so harmful for them, and we'll even take their silly ones about lawyers' time if like that's just going to be more benefits for our side. So then they said that like we were contradicting like whether being quick was like good or bad. And so why is it actually different on both sides? So being quick is bad on their side because there is no checks and balances. They don't have a judge telling them if their search is justifiable. They don't have a judge telling them if they can like search this person's house. They don't have a judge telling them if it's like okay for them to do that. There's no checks. This means that they can be prone to their own personal bias. They can go search someone's house just because they like don't like the color of their skin. There are no checks. This is when being as quick is bad. This is when rash decisions get made. On our side, like yes, a warrant is quick to get. This is good because it means justice can be like served quicker, and but the warrant is like the form of checks. This is where it doesn't matter if it's done quickly because there are people checking to make sure like it's actually being done well and that there's no exploitation. So then they said that like evidence that's used is always accurate, so it doesn't matter if if there's going to be exploitation, it's going to be on both sides. Like firstly, we already explained why this takes longer. We get all of the benefits there, and secondly, there's just like any like more chance of tampering. Like even if they're going to check, there's always going to be a bigger like even if it's like incredibly marginal, there's still just like a bigger chance of tampering. And when it comes down to like predominantly minorities that are going to be affected by this tampering exploitation, and they're things like life in prison, and in countries they're getting like death, this is where it's so harmful. This is where the huge harms are that they have to cop. So secondly on I'll take a POI.
If you believe that the police system and the court system are so unfairly biased towards criminals, why can they not tamper with evidence even when they follow the correct procedures?
So actually, no, I didn't say that. I never said the judges were inherently racist. I never said the police officers were racist. We're just saying that on our side, there's at least a bigger chance of people being open to that. I think it's pretty fair to say that 1 in a million police officers is going to be racist to some degree. Like, I don't think that's that uncharitable. And I think that even if you don't believe any of that, all of our points on why it takes longer on their side still stands, and we can still flip all of your impacts. So secondly, on exploitation, they said that police are punished either side, so there's no like extra incentive to exploit, so people aren't going to be doing it anymore. So why is this not true? Because on our side, police know that there's 0% chance of incorrectly obtained evidence being used in court, and like no matter what their personal bias is, they probably want to do their job well. They probably want the criminal that they like think 100% did it to be convicted. What does this mean? This means when they're getting evidence, they're not going to be like, oh, I'm going to quickly search the car, because they're like, if I find anything in that car, it's not going to be used. I don't want to do that. I am going to run over to a judge's house and get a search warrant, because then my evidence can actually be used. Like, this means that they just take half an hour to get the warrant, and so this evidence can be actually used. This means that there's absolutely zero incentive on our side, even if you believe that like getting in trouble is enough of a deterrence on their side, which first I just don't believe it is, because if it's such a big case like murder or rape, you're probably going to be praised enough as a policeman for like figuring out who did it more than you're going to be like told off for getting evidence that helps solve the case. I don't think this is like much of a deterrent, and at least like if you don't believe any of that, they have some more incentive in the fact that that evidence can actually be used. Like, you cannot say this is symmetrical at all when there's literally zero incentive on our side. Like, so why are the reasons why they wouldn't get a warrant on their side? They're likely because they don't have proper reasoning. Note that you don't even need a warrant. In the info side it says that it's like you can have justified reasoning. Like, you don't even need a warrant. So if it's like not if it's like still seen as like not lawfully obtained, then they probably like have like ulterior alternatives. This means that when it's done, it's likely for bad reasons, whether they're like necessarily bad actors or not. Like, it just means that in this situation it's likely for bad reasons. I'll take a POI.
If the difference is between using this evidence that was already collected and not convicting this person at all, would you let a murderer go free?
So who actually lets more murderers go free? Like, goes into my points on their principle. So they try to say that more victims get justice. Why is this just completely not true? Because it means that, like, even if, like, there's a couple cases where this evidence is completely necessary, and that means that on their side they get some more cases going through. It actually means that when judges, they're like, obviously they're not going to be consistent. Like, when they're deciding whether to use this unlawfully obtained evidence, some of them are going to say no. Note that's, like, specifically especially can apply to things like sexual assault cases. Like, rapists barely get convicted anyway due to lack of evidence. And if on their side a police officer, like, unlawfully obtains evidence, brings this to the judge, tries to appeal for it to, like, be counted in court, the judge says no. There is now absolutely no evidence at all. There is nothing for them to stand on. The rapist does not get convicted. We flip all of their impacts on the victims. Once again, on our side, even if some police officers are still unlawfully obtaining evidence, which I already proved that they're not, it means that, like, the max amount of evidence is being shown in court. There's no chance of evidence being discredited in court. Like, on their side, if you don't get any justice because there's no evidence, this means that it's either symmetrical because people, like, apparently aren't getting justice on either side, or, like, it's not a very high burden to prove. Like, I already proved that there's no incentive to incorrectly collect evidence on our side. No evidence is discounted. Victims actually get justice. They said that so then they said that inconsistency always exists, so our principle, like, doesn't matter and it's all made up. So why is this actually so important? Firstly, on victims, like, if a police officer is lazy and they don't get a warrant, evidence is then dropped and there is no conviction, this victim is then living, that's like, wow, if I just had a more locked-in police officer, my, like, the person that, like, sexually assaulted me would actually be in prison right now. This is when you don't buy into the system. This is when you don't believe in the people that are meant to protect you. And then, like, other people just feel, like, demonized. This is, like, you only need to improve the smallest incentive to exploit to prove that people then don't buy into the system. Minorities are unfairly treated. This is when they don't buy in. This is when they don't believe in the people to protect them. This is when they're more likely to turn towards violent crimes. Note that this doesn't rely on bad judges or bad policemen. People always have biases, and there's just increased inconsistency, and when there's inconsistency, people do not buy in the system. Like, on scale, you can waste so much distrust versus, like, very occasionally someone's not prosecuted. Like, note that I already explained why more people are not prosecuted on their side. That, like, if a cop should have properly attained evidence, it's their burden, not ours, when a rapist doesn't get convicted. We should never have to stand for a world where police are above the rules and they don't have to follow their own rules. We stand for a world where police are more incentivized to follow the rules, more people are convicted, more victims get justice.
I think they misunderstood our case, because we never said that we had to make a trade-off between efficiency and making sure that this evidence was correct. We think we can claim both, and that is why the justice system is just simply better on our side of the house. I'm going to do three things in this speech. Firstly, I'm going to introduce a really key piece of framing that was left out. Secondly, I'm going to talk about, is this evidence correct / is it right? Like, will it be used efficiently? And finally, on this idea of the principle of consistency and weighing that against our principle of future victims. Firstly then, in terms of two key pieces of framing, I think you ought to know here. The first piece of framing was brought to you at Bell, which never got responded to, and this is crucial, because we told you, the instances in which this was going to be used in serious cases that otherwise would have taken massive amounts of time in the comparative. It would have taken massive amounts of time in the comparative because oftentimes it was ambiguous, because it was subtle, because you didn't have these key pieces of evidence to your discretion. That was extremely important, because it doesn't mean that we're more prone to making mistakes. We're simply reducing the time it takes for these cases to be dealt with. That was the framing that was left out and unresponded to by their side of the house. But the second thing I want to deal with, second piece of framing here, is to characterize what type of cases these look like. Because opposition seems to care a lot about minorities. So let's win on minorities here. There are probably three types of criminal cases, right? One, it's probably a minority to minority. So I don't think discrimination or bias matters here. But two, it's probably the minority is the perpetrator and the majority is the victim. But the third case is when the minority is the victim and the majority is the abuser. When the minority is the victim, this is more likely because obviously the majority thinks they can get more away with these crimes. The majority thinks there's less surveillance in these areas, so oftentimes the evidence that they collect is so murky. Why is this so important? Because it means when the minorities are the victims, it means that they are more prone to bias. When the minorities are the victims on their side of the house in these cases, that is when they are vulnerable. That is when these judges and juries who might have biases are going to vote against them because they did not provide sufficient evidence. And I want you to note the burden of the motion, because clearly it states here, excluding the evidence would significantly harm the prosecution case. So in these instances, it was far more likely that minority victims were likely going to lose. And insofar as you care about bias, we think we can win on their turf as well. These two pieces of framing are crucial because I think it already flips you why minorities are better on our side of the house and why we don't have to make this trade-off between efficiency and making sure that this evidence was right. But let's chat about these issues. Firstly then, in terms of was this evidence correct/good? Secondly, were there harms to efficiency as a result of it? Firstly, was this improperly collected evidence correct/good? We gave you a host of analysis as to why this stuff was likely to be good. One, we told you that this was likely going to be collected by the police. And no, the same incentives to make it right on both sides of the house still exist. Sarissa gave you examples of body cams. We got no response from their side. But two, we want to frame what most of this evidence looks like, right? Because if it was so harmful to the prosecution case, it likely looks like things like surveillance footage, which are literally objective. You cannot tamper with it. Why? Because obviously these things would contribute significantly to their case. So the type of evidence is probably going to be objective in a lot of the instances. Otherwise, it's unclear why they will be useful for the prosecution case, etc. But thirdly, we just told you that oftentimes, like, if people knew that they were going to get a search warrant and know that search warrants just objectively do not take a lot of time because you have to do things like get probable cause, etc., which means it doesn't just take 20 minutes to do it as such. It means that on their side of the house, oftentimes they can hide evidence. Oftentimes they can do things to conceal and obfuscate the evidence. Comparatively on our side of the house, even if you have to do it by surprise, even if you do it faster, we say that there's less chance for this evidence to be tampered with by the criminal himself. There's less chance for the evidence to be dealt with by the people who actually committed the crime. And we'd say the criminals are likely going to be far more dangerous in terms of tampering with the evidence. Why? Because obviously the police still have incentives to do justice. The police still have incentives to do well, which should explain to you then that it's better for the police to find out this evidence faster than it is for a criminal to potentially hide away evidence or store away evidence because it was improperly obtained and they needed a search warrant on their side of the house. And note this response to this idea that we're prone to mistakes. We're simply not prone to mistakes because we're just getting more evidence. What was their response? Their response was just that police could simply just tamper with this evidence. The first thing we told you was that this is just not going to be harmful. It looks like objective surveillance footage. We're unclear how you're going to tamper with that. But two, we literally gave you the risks from Sarissa, right? We told you that one, police do not want to do this improperly because one, they have body cams, etc. But two, they literally risk losing their job on our side of the house. That is why they do not want to collect this evidence improperly or in such a way that they're going to tamper with the evidence. But they never explained to us why they had the incentives to do so anyways. But secondly, we told you that obviously, even if this evidence is tampered with, it's still up to the discretion of the judge and the jury to decide if this evidence was good or not. We didn't have to buy that. We had to use this evidence in every single scenario. We just had to support that we could use it in certain instances, and in these instances, even if it was tampered with, there's a second barrier in terms of judges, in terms of the jury deciding whether this evidence was good or not. But finally, we just also respond to the claim that we make bad decisions. Insofar as you get more information, insofar as this information is more well informed, then you think we just make better cases and more right cases on our side of the house. So the implication of all this analysis is that on our side of the house, we never had to defend that we were always going to use this improper evidence. It was up to the judge's discretion, and obviously they've been through elite training, so this was likely going to be good. That's crucial because it means that the evidence collected is likely going to lead to a better result. And insofar as you care about minorities, insofar as you care about victims, then we say that having this better result was likely going to be good. But even if we didn't have that, we had efficiency. We explained to you that you're likely going to get efficiency because the cases, serious cases, often take months and months and months. If we can reduce that by introducing improper evidence, it means that you're able to get more cases out. You're able to get 20 criminals locked away in jail instead of just 10 criminals on their side of the house. So if you cared about it, we also won on efficiency. And that was extremely important because Bella gave you the impacts. It meant less worry. It meant less money spent on lawyers, and it meant more safety and catharsis for these people in this debate. That will weigh be highly, because even if in our worst case we get efficiency, and efficiency was so much more important because it meant more criminals were likely to be locked away. Before I get into the final part about the principle, I'll take a POI.
Would you not agree that it's better if all evidence is always counted because it's always collected properly on our side?
But the thing is, there's literally laws that prevent that from happening, right? So I'm unclear as to why this evidence is allowed in the first place. It was inadmissible in the first place. Finally then, on the principle. And the reason why I don't leave a lot of time for this is because I think we can fulfill their principle better than they can fulfill their principle. Because insofar as we make the best decisions, or insofar as we make faster decisions, which meant that more criminals locked away, that means that the principle of consistency was dealt with on our side of the house, because we made more right decisions. I think making more right decisions is better than making more consistent decisions, because that simply means it has tangible impacts. It means that criminals get locked away, etc., etc., etc. But we told you, at the end here, I just want to weigh why this principle of future victims was so important. Because one, Sarissa explained to you that it's crucial. And not the burden of the motion here. This was in instances where evidence would significantly harm the prosecution case. So you all buy that this was some serious case and that could protect a lot of future victims as such. But finally, these victims were innocent. The people in the public are innocent. If there is any way that you can protect these people who never had a chance of committing a crime, that was important, because you protected the people that were innocent and the people that were not. At the end of the speech, then, we never had to concede that we lost on efficiency and making the right decision. We think we win on both. But even if we didn't, efficiency was so much more important than the prior thing, and that is why we win this debate.
I'd like to thank that speaker for their speech. Now the speaking roles will be reversed. So I'd like to welcome up the reply speaker for the negating team.
I think everyone in this room is incredibly smart, but if it wasn't clear already, it is so much harder and it takes so much more time to convict a person to a lifetime of prison without full information than the time it takes to actually verify if evidence is accurate. We win today's debate very clearly because we proved to you 3 things. The first thing we proved to you was why the principle clearly does not exist. They cannot win on this principle. But the second thing we proved is how we are able to uniquely get this benefit of efficiency on our side of the house. The final thing we proved to you was how we are able to improve the justice system in terms of how it is going to impact individual lives. The first thing I'm going to talk about then is on minorities. Note here I'm just going to extend on Josh's speech. I'm not going to spend too much time on here because I think after Josh's speech you should believe we are already clearly ahead. Minorities are going to be disadvantaged structurally. Unfortunately, this is the sad truth. But look, we explained down the line why judges and police are going to be good. They have incentives to act well, act honorably. We gave you 5 reasons as to why judges are good. They didn't respond to these. We also gave you a multitude of reasons as to why police act well. I think we need to sense check the argument, because affirmatives claim to access all of their benefits, and now you're going to suddenly randomly search the bodies of minorities. You're going to suddenly act super rashly. I just don't think this is going to happen, because even if police are racist, there's still going to be people who are going to serve their communities. They're still going to act honorably. They don't want to go to bed and think that they are a terrible person. They don't want to wake up, look in the mirror in the morning and think, wow, I just assaulted a minority the other day. I think we need to sense check their material. Because to access the extent of the harms that they claim, you have to believe that the police are just all evil beings. I don't think this is the case. Look, even if they aren't good, there are accountability mechanisms. They have to make decisions well. But we explained to you why the lack of information means that the decisions are just going to favor majorities and going to harm minorities even more. Because the only way to help minorities is by providing full data. Note here we also give you implicit framing in our case about how backlogs are going to harm minorities more. Because minorities have less money. If they have to spend more time in the justice system, they have to spend more time waiting for a decision, this is going to disproportionately harm them. We are able to decrease backlogs, we are going to win. But before I move on to the efficiency, Even if you think we lost on minority individuals because they are unfortunate and that racist police is going to target them, we were able to help minority communities. This was an exclusive benefit that Bella explained to you. At first, we never got any response. I think we're able to win on that. But then, how are we able to increase efficiency? Josh explained why this is a huge benefit because it means large-scale improvements. It means you are able to actually get criminals convicted because you now have the accurate information. In affirmative's world, in the comparative, you have the same data, you have reached the same principles, but you are unable to ever use it, you are unable to actualize the results, you are unable to get benefits for individuals. Because these criminals are still going to lurk around communities, you are never able to get proper evidence to convict them. The framing here is just that once the case has passed, it is hard to get further data. The reason why it is so hard and why it is so slow in the status quo is because it is hard to get data. We allow this improperly obtained evidence to be used, we are able to let the justice system actually function. The mistake that affirmative made in this debate was to hand wave all of our benefits and improvements to efficiency and call them silly impacts. At the end of this debate, our impacts were never silly because they illustrated the immense harms that you bring to victims. They illustrated how we are able to actually upkeep a functioning justice system. Our impacts prove to you why we have to allow courts to use improperly obtained evidence, because oftentimes it is the only way you are ever able to convict murderers. It is the only way you are able to protect future victims from being assaulted, from being raped, to being literally killed and losing their lives. If you care about the justice system actually being able to function, if you care about the safety of individuals, of communities, you have to side with negating. It is clear that we win. I've never been prouder to negate.
I thank that speaker for their speech, and I now offer up the space to the reply for the affirmative.
AF gets more people convicted when we don't depend on unverifiable evidence. And exclusively, we have no chance of wrongfully imprisoning innocent people. This means you don't get a life wasted suffering in jail. You don't get people disenfranchised and scared by an inconsistent legal system. That is huge. So, look, firstly, I just want to remind you of the framing because it gets quite lost in the negating case. Inadmissible evidence is stuff that is previously not reliable or not verifiable in the status quo, because if it was, it would be admissible on our side of the house. I clarify this at second, and I think it's clear from Layla's setup. NIG is making a change that then allows this evidence to be admitted in certain circumstances. This is principally and practically abhorrent as I'm about to tell you. So firstly on efficiency, then on consistency, then on the process. Look, firstly on efficiency, because I think this is where their case sort of boils down to by the end. Look, we firstly tell you from second that it's just bad to be efficient, right? Because that is the point where you act irrationally and you act in a way that is unsafe. You risk the lives of police officers. But secondly, it's ineffective because you get lower quality evidence when it is less creditable and when it's more likely that you make fumbles, like allowing the criminal to just toss a weapon out the window because you didn't go in with a good plan. So what this means is they're far more likely then to get wrong convictions or to get no conviction at all. So efficiency doesn't matter. They make a supplementary push here that victims spend a lot of money on the prosecution, but note that you generally get the prosecution is generally done by the state. We tell you this down the line. But also we can quite heavily mitigate this point because I don't think the cost to the government is really a real impact here when we're talking about lives rotted away in prison and victims not getting the justice they deserve. So then on consistency, which I think this principle gets unfairly addressed by the negating team, because they tell us the only real pushback is every case is different. This just doesn't engage with the evidence we give you at Layla, because normally we have precedent that indicates how cases are consistently covered across all courts. This is the entire point of the legal system. We actively prioritize consistency through each case, even if they are different. They all we apply the legislation in the same way. But other than that, the only push they give us is principles are made up and they don't exist. not when inconsistency is prone to bias, mistakes, and discretion, which, by the way, all disproportionately affect underrepresented groups, even if it's not intentional, even if judges and police aren't malicious, right? So, but at the very least on this principle, it's at least perceived as being inconsistent, right? This means minority and suppressed groups have more fear of getting profiled. At the very least, then, they have less trust in the system. Minorities don't feel represented. That is a huge impact that just completely gets unengaged with from Layla's wonderful presentation. So then on the process, look, they tell us they make a case pivot at second neg that saying that now we already have the evidence, so we're not getting new evidence. Look, firstly, it's still unverifiable, but secondly, it's still subjectively applied, right? It depends on who has the most motivated prosecution to advocate to the judge for the evidence to be allowed. We tell you this at Layla again, but it also depends on who has the most influenceable judge and whose judge is more likely to sway in their favor. We tell you this means that sexual assault victims are less likely to have evidence admitted. But then we tell you and give you structural reasons, by the way, why it incentivizes more regular use, right? Just the laziness of avoiding paperwork, or like less cost of policing on like CCTV. Like if the police and justice system are as underfunded as they say, then surely this is a good incentive. But firstly, this means they make more mistakes, they fumble more evidence, but secondly, it's unreliable, and thirdly, it's targeted, right? Look, we never tell you it's only minorities and all police are inherently racist. We tell you that they make mistakes that affect everyone, but it's more likely that they affect unrepresented communities because they are prone to bias. Look, they can't have body cams because it's not verifiable evidence if it wasn't admissible. I think we win on protecting victims and protecting wrongful imprisonment.
Okay, I thank that speaker for their speech. That now concludes this debate. I would ask each team to please stand up, cross the floor, and shake the other team's hands, and I will shut this room.
Which is our audience on 5 6.
Oh, it's a
Heading out
song.
of the room.